Hello, hello. How is everybody doing today? Right, we've got 8 people who have filed in so far. Welcome everyone to our conversation today around celebrating the 36th anniversary of the ADA. We'll give this just another minute or two before we get started with the presentation, just to give people a little more time to jump in before we get going. Okay, I think now is probably about as good of a time as any to kick things off. Welcome, welcome, all attendees to this presentation from the Comlaw Group and Allyable. My name is Stephen Alomar. I am the head of marketing at Allyable, and I will be moderating this conversation today between our two presenters, which is Michael Nowicki of the Comlaw Group, who is a senior attorney there, and also our CEO at Allyable, David D., who is an expert in accessibility technology. And I will now basically take this to kick it off to Michael to let him give his own presentation of himself.
Thank
Michael,
you,
can you see my
Stephen.
can you see my screen? I just want to make sure.
Yes, we see.
Excellent. Cool. Please, Michael.
Great. Well, thank you very much for this opportunity to present and be here with everyone. I hope you're all having a wonderful day. My name is Michael Novitsky, and I am a digital accessibility regulatory compliance attorney at the Comlaw Group, which is a full-service telecom law firm that also touches on various other aspects of the communications and technology sector. I specialize in both US and Canadian accessibility laws, including the ADA, 21st Century Communications and Video Accessibility Act, and in Canada, the Accessible Canada Act. Apart from my work as a digital accessibility attorney, I am also active in the National Federation of the Blind of Illinois, serving as the organization's treasurer, as well as co-chairing its resolutions and advocacy committees, which significantly shape the organization's policies. I have been blind all my life, and for that reason, I have developed a strong personal interest and passion for accessibility. I use screen reading technology on various platforms, computers, mobile devices, and even my smartwatch. So I also have deep personal familiarity with assistive technology and understand firsthand the importance of digital accessibility to people with disabilities.
Thank
Stephen,
you,
you are
Michael.
on mute.
Thank you, Michael. Thank you very much. And now I shall hand it over to David. You can walk through your bio, please, if you don't mind.
So, good morning, everyone. Good afternoon. And thank you very much for joining us. I'm David Adi. I am the founder and CEO of Allyable. And as a disabled person with a long track records in technology and in digital accessibility, I I found the company in a way that built a platform that will help to any organization to gain control on the digital accessibility journey, provide them the tools, the knowledge, and of course our expertise in order to helping them achieve the goal and make the world much more accessible. And with, of course, fully compliance with the ADA, the Section 508, Section 504, AODA, EAA, and rest of regulations, and being acknowledged as a worldwide expert in digital accessibility by the United Nations, the European Union, and by the US government. And some of my patents that I registered has been approved worldwide. I'm very excited about this webinar. I think that it could help us to explain a bit more about the ADA, why it's important, why it's something that it's not just about the compliance itself. It could lead us to better service, to provide better customer experience. And of course, in the end, organizations that will do accessibility right will achieve better revenues, better numbers, and the most important, as a social responsibility, will provide equal access to all. So thank you very much that you're here, and go ahead.
David, do you want to mention
That's
some of our clientele?
Sure, absolutely. So as Allyable, we serve some of the biggest brands in the world. We are proud of that. We see them, all of them, as partners, not as customers, because it's a journey. It's a never-end story. You need to invest and design with accessibility in mind. You need to change the mindset to understand that it's not only because it's required by law. It's required because everyone needs it. And once this mindset set properly in the organization, the investment done correct, and the work done correct, and as a result of that, we're proud to serve some of the big brands.
Excellent. Okay, so let's get into the meat and potatoes of today's conversation. So, Michael, I'm going to throw it to you to give us sort of an overview of the ADA and the 4 pillars of the Americans with Disabilities Act. I know that there are 5 titles, but there are 4 that we're really going to be speaking about today. So please take it away and enlighten us.
Thank you. So as Stephen briefly pointed out, there are indeed 5 titles to the ADA. We are going to focus on 4 of the 5 titles, because Title 5 essentially consists of miscellaneous provisions only. It doesn't really impose any substantive obligations. So with that background, Title 1 deals with employment. It prohibits discrimination on the basis of disability against qualified employees with disabilities. So qualified means that the employee needs to be able to perform the essential functions of their job. So the ADA is not a preferential treatment law. It is an equal access law. So it does not obligate someone to hire somebody who would not be able to do their job with or without reasonable accommodations. But if with or without such accommodations, the person can do their job, then they are protected by Title I of the ADA. Now, out of all the actually, I'll back up one step here. I also want to highlight that Title I does also cover job applicants with disabilities. So it does require accommodations and effective communications in the application process, including making sure that applicants are not screened out on the basis of their disability, that they get the accommodations they need during the interview process, that job boards and other job application channels are accessible to people with disabilities. Title I is the least digital of the 4 substantive titles of the ADA, in the sense that there is the least guidance or technical standards on what employers need to do in terms of their digital platforms. They are required to provide accommodations, but there aren't proactive standards as to workplace technology. That is something that the disability community is pushing for, and the National Federation of the Blind has even enacted a resolution on this, addressing this issue at this year's convention of the organization. Then we have Title II, which requires equal access to the programs, services, and activities of public entities. Now, the ADA defines public entities to exclude federal entities, but it includes state and local governments, as well as their subdivisions, which broadly encompasses not just the 3 branches of each state and local government, but also state universities, public schools, public healthcare providers, providers of public transportation. So it broadly encompasses.
I imagine, Michael, universities also probably, universities and educational facilities also fall under that blanket.
Absolutely. Public universities fall under Title II of the ADA. Private universities do not, but they are covered by another law, which I will get into a little bit later.
Excellent.
Then Title III requires equal access to the goods, services, privileges, advantages of places of public accommodation. So that applies to the private sector. It applies to places of lodging, like hotels, motels, dining establishments, bars.
This is the one that you've described to me as one of the murkier sort of titles of it, where there's a little bit of confusion between what exactly counts as a public accommodation and what's not. Correct?
Yes, that is correct. It clearly applies to bricks and mortar establishments, but courts are divided as to which websites are covered by Title III. And for that reason, as we will get into later, it has created a flurry of litigation around what is and what is not required.
Great.
And then Title IV establishes telecommunications relay services for people who cannot or have difficulty participating in traditional voice telephone calls, primarily people who are deaf, hard of hearing, deaf-blind, or have speech disabilities. And they mainly communicate through either a relay operator or through automated solutions that allow them to communicate over the telephone using text or sign language. And that covers the 4 pillars of the ADA.
Right, but that's not the only. The Americans with Disabilities Act is, even though we're celebrating the 36th anniversary of the Americans with Disabilities Act, that is not the only set of laws that we are really looking at today, because there are more, as I understand it. There's a broader accessibility legal landscape, and I would love for you to walk us through that as well, Michael, because there's different sections of different laws as well that are broadly applied.
That is correct. And because of that, it is important for covered entities to be aware of all the laws that may potentially apply to their facilities, websites, mobile apps, products, services, anything that they offer. So we don't have time during this event to get into any of those laws in details, but I will provide an overview for all of you to kind of get a sense of what's out there and what you may need to evaluate. First up, we've got Section 504 of the Rehabilitation Act, which prohibits discrimination in programs and activities receiving federal financial assistance. So that is pretty broad. It applies to both the public and private sector. It applies to private colleges and universities, for example, because almost all schools participate in federal student loan and grant programs, and because some of that money is channeled through them, and their financial aid offices facilitate disbursements. That's one of the things that brings them within the scope of Section 504. And I mean, substantively, Section 504 requires a comparable level of equal access that is provided under the ADA. Then we have Section 508 of the Rehabilitation Act, which is a more technology-focused law. It requires the executive branch of the federal government to procure, maintain, and use electronic and information technology that is accessible to employees and members of the public with disabilities. This is where we get into the concepts of the VPAT, the Voluntary Product Accessibility Template, which is used to prepare the accessibility conformance report. And if your company serves those federal agencies, or if you are federal agencies, you probably are already demanding that documentation to make sure that you satisfy your obligations to procure accessible technology. Then we get into more product-specific accessibility laws, specifically the 21st Century Communications and Video Accessibility Act of 2010, CVAA, and its predecessor, Section 255 of the Communications Act. Those laws mandate accessibility for telecom equipment and services, including handsets, modems, fax machines, web browsers built into cell phone, and any equipment that is capable of playing audio and video at the same time, including smart TVs, smart refrigerators that have tablets that can play video with audio, Blu-ray players, DVD players, set-top boxes, computers, tablets, and it also imposes requirements for the accessibility of video content, such as accessibility of emergency information, emergency alerts, like the crawls that you get on TV when there's a hurricane coming, or flood watch, as well as closed captioning for people with hearing disabilities, and audio description for people who are blind, which is the insertion of a verbal narration of visual elements of a program, typically between pauses in the dialogue. Then the Air Carrier Access Act, that predates the ADA, that requires airlines to make their services accessible to passengers with disabilities. And then finally, I do want to note that many states and municipalities have enacted their own ADA-like laws, which in some cases offer greater protections to people with disabilities to those that are available under federal law, such as by authorizing statutory damages that are not available under Title III of the ADA.
Awesome.
So that is a brief overview of federal accessibility landscape.
Thank you for that 35,000-foot view of what is a very in-depth topic. Excuse me. So I think most of the people on today, me certainly, as someone who's worked in technology for a long time, is really wondering about the question. Now that we have this 35,000-foot view of both the ADA and some of the subsequent laws that would be applied to all of us sort of out there working in the world, does ADA Title III apply to websites and mobile apps, and how does that apply? This was the one that was, we said earlier in the conversation, was a little bit murkier, and it was a little hard to tell. There's a lot of litigation sort of around this. So if you would walk us through sort of, Michael, the current status quo of what we're dealing with, that would be great.
Absolutely. So I will start by talking a little bit about the historical context of the ADA. So when the ADA was enacted in 1990, very few people used the internet on a daily basis. And even those who did certainly did not use the internet in the way that it is used today. As a result, the ADA does not specifically address its applicability to websites or mobile apps. And the U.S. Department of Justice, which has been entrusted with promulgating regulations under Title III, has never promulgated such regulations. So with that context, that has created significant ambiguity. That said, the U.S. Department of Justice's position has consistently been that the ADA does apply to websites, but a split has arisen as to what types of websites it applies to. So the issue boils down to this: we have a majority rule that in order for a website to be covered, it must have a nexus to a bricks and mortar establishment, such as, for example, the website of a restaurant or a physical retail store is covered because it functions effectively as an extension of the physical place of public accommodation. So that rule applies in states like California, Florida. So basically, like in the third, ninth, 11th judicial circuits. But then there are some courts, including the First Circuit, the Seventh Circuit, and some trial courts in the Second Circuit, which encompass states like Massachusetts, New York, most of the Midwest, that have decided that it doesn't matter if your website is linked to a physical place of public accommodation or not, because ultimately businesses are going increasingly online, and the ADA, even though it does not specifically mention websites, it has always been intended to apply broadly. That was the legislative intent. And one landmark case that I would like to draw everyone's attention to in regards to that position is National Association of the Deaf versus Netflix. That is a case where a deaf plaintiff filed a lawsuit in Massachusetts claiming that Netflix is a place of public accommodation and that it is required to provide closed captioning for all its contents. And the defendants, Netflix tried to get the case dismissed. They lost. The court found that Netflix is a place of public accommodation. That it does not need to be linked to any bricks and mortar establishment, and that ultimately paved the road to much more widespread availability of closed captioning in the shows that we can stream today on platforms like Netflix, Hulu, Disney Plus, Peacock, and so on.
So just to sort of give a little summation here. So basically, anybody who is got a brick and mortar business and then a digital presence on top of that, and then also basically anyone who would accept sort of payment through a website for a good or service of some kind. is going to be covered somewhere in the United States. So if you're doing business in any of the 50 states, essentially, or all of the 50 states, if you're covered, maybe like, there's a niche position where you're maybe a plumber in Texas or something, like where maybe it doesn't quite cover you, but for the broad part, anybody who is brick and mortar business with a digital extension, anybody who is accepting payments basically for good or service is going to be covered somewhere within the United States by Title III, correct?
That is correct, Stephen. And one thing that I would like to expand upon that is that even if a business is digital only, but the business has more or less national presence, or even an international presence, the business should not assume that the nexus requirement under the majority rule will protect them, because if say a blind plaintiff who relies on a screen reader to access websites cannot access the site and wants to sue that company to force it to make its website accessible, then the plaintiff, will do forum shopping and be careful to bring the lawsuit in one of those jurisdictions where a nexus to a bricks and mortar establishment is not required.
Right. Understood.
Michal, if
Sorry,
I may,
David, go ahead.
Could you a little bit explain about the connection between the Canadian and the European Act and the connection to the ADA? I think it's important because we speak in all the time domestic, but businesses also could be exposure internationally. And I think that the audience will be more than happy to understand how it's connected.
Of course. So as a general rule, to the extent a business operates in multiple markets, that business is subject to the laws of each market in which it operates, including accessibility laws. So if a business, for example, sells its products both in the US, Canada, and Europe, it needs to make sure that it is in compliance with all applicable laws in those markets. So in Canada, for instance, there is the Accessible Canada Act, which applies to all entities that operate within the federal jurisdiction of Parliament. That law imposes planning and reporting obligations. The entities must have an accessibility feedback process, a 3-year accessibility plan. They must publish progress reports on the implementation of the plan in the years between when their updated accessibility plans are due. There are also provincial laws. The most comprehensive of those is the AODA, the Accessibility for Ontarians with Disabilities Act. And then recently, Europe enacted the European Accessibility Act, which covers a wide range of consumer-facing products and services. And each of those laws do require conformance to different accessibility standards. The good news is that all those accessibility standards build on the World Wide Web Consortium's Web Content Accessibility Guidelines, WCAG. So WCAG can be used as a foundation to comply with all these standards. And the bottom line is that if your company or organization is subject to more than one of these laws, then it should aim to comply with the highest standard to ensure full compliance with all the accessibility laws in each market in which it operates.
Thank you for the clarification.
Yeah, we appreciate that, Michael. Before we move on to the next slide about sort of the more recent developments in the ADA, I did want to ask really quick, and David, I'd love to bring you in here too. Um, Given the National Federation for Deaf and versus Netflix case, if I've got that right, Michael, um, what what was sort of the reason why the Netflix Corporation wanted to actually fight that out in court? It would seem that given the number of people who require accessibility standards and best practices, they would maybe want to just do that voluntarily. Why did given the number of people that were potential customers who are not benefiting from a product or service, that maybe they would want to um, fight that out in court as opposed to just voluntarily saying, okay, well, if we have recognizing that if we have people who are hard of hearing or um, have other issues, that we will just go ahead and voluntarily go through with making our own products accessible. I would love to hear both of your opinions sort of on that, of what I know no one can get in somebody else's headspace, but just sort of if you guys can pontificate on it for a second, I'd love to hear.
Yeah, well, I'm thinking that again, I cannot understand how the decision taken in Netflix, uh, but I could guess that during this time, a lot of organization they lead by revenues or lead by profitable, and to invest something like that when back in the days it was a little bit more complex. It's require a lot of first to understand and the knowledge that's require training and experience. Second, to do the job and to invest in that, it's required also technologies and some consultant, etc., that lead to expenses and labor that take it time. And on top of that, of course, legal advice to see that what they do it correct. I think back in the days, many organizations didn't understand and realize the amounts of people that could benefit from such a kind, and each person potential customer, mostly for Netflix. I don't believe that I know someone that doesn't know who is like Netflix and to use Netflix. And this lead to, I think, bad decision to fight in court and say, hey, we want to save time, we want to save money, we don't know why it's so important, etc. And today with AI and new technologies that even Allyable have some of these features, it's become much more easier. And as a result of that, it also could lead to more better customer experience. As the customer's happy and satisfied, you just buy more, you just use more. And I think this is a very important topic to discuss in general. It's not only about compliance. It's about how you provide a better service that will lead to your customers and to your brand to rise. And as a result of that, your bottom lines will increase. So again, that's, I think, was the main reason. And today, with the existing technology and the advanced technology, I assume that it should be better and faster for any organization. And I think that also the awareness increase. We will see in the next 2-3 years if it's really changed the gear.
Michael, so for David, if I could sum up basically for the audience, essentially it was a lack of knowledge about how to do it, how to get things done. The team not really wanting to take on sort of another sort of challenge in addition to, product people love to build, but they don't really love to go back and refit what they've already built. And just the time and expense was outweighed by basically fighting it out in court. Michael, is that sort of how you see it as well? Being an expert sort of probably in that case and on the law?
That is definitely part of it, but there is another important potential factor that I would like to highlight, and that is the allocation of responsibilities for incorporating these accessibility features between the entities involved in the video production supply chain. So when we watch a video on any of these streaming platforms, we don't necessarily think about who was actually involved in putting it together. I mean, uh, there is a distributor like Netflix through which the video is actually made available, but then there are studios and potentially other entities involved in the content creation process. Um, so bringing in copyright, other intellectual property, and licensing considerations, there is some complexity there as to figuring out who should actually be responsible for making sure that the captions are created for the video and then ultimately incorporated into it and delivered to the end user via the stream. So I suspect, obviously, like David, I can't get into the heads of these companies to confirm definitively what drove their decision making, but I suspect that was a significant contributing factor as well.
That's really interesting. So basically, the idea that like if you are putting out a final product of some kind and you're the one presenting it, you also have to think through the accessibility requirements in the supply chain as well, correct?
Exactly. I mean, if you get a video that has no captions and you either want to include captions voluntarily or are required to do so by law, then you either have to go back to the person from whom you got the video and ask them, "Hey, I need you to add captions to this," or uh, caption the video yourself and make sure that doesn't cause any issue with your relationship with the provider. Because if you also caption it without their permission, that could create some legal stickiness between your business and your supplier.
It's really interesting. So if I'm say, I don't know, a digital accessibility platform and I have got sort of instructional videos and I let's say hire those out, really instructional videos about how to use my platform. Um, maybe digital accessibility provider is not the best example here, but if I am basically some sort of provider of a service, I contract out to have somebody else create videos for me. If they are not accessible as well, I am on the hook. If I then take those videos and then I put them forward and incorporate them into my platform and training.
Correct. In short, you can delegate away performance, but you can't delegate away your legal responsibility for compliance.
That's a really interesting point and something that I think everyone will want to sort of take back with them. As someone who has worked in marketing for a long time and has definitely contracted out for a lot of different services. So that brings us, guys, to sort of recent DOJ digital accessibility regulations under Title II, which is sort of an ongoing and moving target. And I would love, Michael, for you to sort of kick this part of the conversation off and sort of bring us through what's going on today.
Yes. So incidentally, under both Title II and Title III, the DOJ issued an advance notice of proposed rulemaking for web accessibility regulations all the way back in 2010 under the Obama administration. That didn't go anywhere. And then in 2017, the Trump administration formally withdrew that NPRM. And then the Biden administration reinitiated the NPRM just under Title II. And then in 2024, the regulations, web accessibility regulations for Title II finally came down. So those regulations with limited exceptions, require the websites, mobile apps, and electronic documents of covered entities, that is public entities at the state and local level, including universities and healthcare providers, all the entities covered by Title II that I discussed earlier, to be accessible to people with disabilities and to specifically conform to WCAG 2.1 level A and double A success criteria. So that is a pretty high standard. It is a standard that was carefully negotiated along with the exceptions between disability rights organizations and government entities. For the electronic documents component, I want to stress that that covers also things like documents posted in word processing formats, spreadsheets, PowerPoint presentations, and PDF documents. So these requirements were originally slated to go in effect for jurisdictions with a population of more than 50,000 starting April 24th of this year, and for smaller organizations and special purpose districts starting April 24th, 2027. Well, at the last minute, some small counties and other covered entities that were concerned about not meeting the deadlines started putting increasing pressure on the DOJ to either cut down on the obligations or delay the compliance deadline. And as a result of that, the DOJ issued what is called an interim final rule, which is an emergency mechanism under the Administrative Procedure Act that delayed those compliance deadlines by a year. So as of now, the deadlines for large jurisdictions are April 2027, and for smaller ones, April 2028. Well, very soon after that happens, the National Federation of the Blind, not surprisingly, got very angry and sued the DOJ as well as the Department of Health and Human Services, which promulgated similar web accessibility regulations under Section 504 of the Rehabilitation Act for healthcare providers receiving federal financial assistance. And they delayed the deadline of those regulations by a year as well. And that lawsuit essentially claims that the DOJ and HHS acted unlawfully in issuing these extensions. They are citing that there was no good cause to extend the deadlines because it wasn't a genuine emergency for which this mechanism is reserved, that they didn't offer a sufficient notice and comment period for the public to weigh in, and that as a result, if these extensions are allowed to stand, the public would essentially lose their voice in government. So we don't know at this point how the court will rule in this lawsuit. It is something that I will definitely watch closely personally, and definitely encourage anyone who is directly impacted by those regulations to watch closely. But one thing that I do want to make plain is that while the deadlines are delayed, those regulations do still remain on the books. And if covered entities slow down or stop their accessibility efforts, it's going to be much harder to gather the momentum to restore efforts to come into full compliance. And I also do want to highlight that even absent these regulations, the underlying obligations to accommodate people with disabilities, to provide auxiliary aids, to communicate effectively with people with disabilities and their companions, all still remain in place. So even absent these rules, the DOJ, courts, and people with disabilities and the organizations that represent them still expect, require, and demand websites, mobile apps, and electronic documents to be accessible to people with disabilities.
So, just to follow up on that, so what happens if, say, I basically find myself in a position where the court rules that those original deadlines are actually valid and sort of reinstates them, and then I still haven't, let's say, the I believe you said 2024 as one of the benchmarks. I still haven't covered myself yet because the deadline keeps getting kicked down the line. But I find myself where, okay, I haven't complied with it yet because I kept thinking, oh, well, this is something I can put off because the deadline keeps getting kicked. But the court says then, no, that original deadline was valid. Is there a grace period, or am I just sort of openly exposed to legal action at that point?
Well, that would depend on the specifics of the court's ruling. If the court were to decide that you should have known that this was coming and should not have used the extension as an excuse to delay your compliance programs, then the entity would certainly be exposed to legal action, either brought by the DOJ or more likely brought through private lawsuits by aggrieved plaintiffs and organizations like the NFB or NAD who advocates for their rights, which is another reason for continuing to move forward and acting as much as possible as if the extension were never issued.
So, is pleading ignorance an option in any way?
Pleading ignorance is not an option. There are some defenses under the regulations. There's an underburden defense. There is a fundamental alteration defense. There are some exceptions for certain, like, pre-existing content that was posted prior to the regulations, or certain content that is posted by third parties that is beyond the control of the entity. But if none of those defenses specifically applies, then no, pleading ignorance is not an excuse.
Okay, so that should basically light a fire under everybody who is listening to this conversation about why it is good to get on the right side of the law and not wait. So, Michael, before we hand it off to sort of David's sort of portion of the presentation, I just would like you to take us through, since digital accessibility is a legal requirement, and I mean, it is a best practice, but it's not just a best practice. What would you normally recommend for the people that you are advising of if they need to get on the right side of the law? What is the process through which they would do that?
Yeah, so the first step is to confirm what you already have in terms of products, electronic documents, services, websites, mobile apps. And then I would recommend at least some sort of an accessibility audit to determine how accessible or inaccessible they are currently. I understand that some organizations, especially small and mid-sized businesses, may not have the resources for a comprehensive audit, especially of a complex, multifaceted product. But even in that case, a high-level triage audit, even if it's more geared towards functional performance standard, like, can this be used by someone who uses screen reader? Can it be used by somebody who relies on screen magnification? Are there any, if there are videos, do they have closed captioning and or audio description? Are the captions accurate, synchronous? So that would be my recommended next step then, to find out where you are in terms of accessibility, and then after that, it gets into developing an accessibility program, remediating anything that is not accessible, making sure to train people at the company on accessibility best practices, because successful companies that have robust accessibility have accessibility ingrained into their culture. And most importantly, going forward, to incorporate accessibility into every stage of the design process. The earlier developers start to consider accessibility, and I'm sure David has a lot more to say about that, the easier it is to make the product accessible. If you have to retrofit an accessible product later, that is much more costly, much more time consuming, and much more exhausting.
No kidding. The phrase that is commonly thrown around is shift left, and in the development cycle, and which, David, I think this leads us very nicely into, if you could start to take us through what the ideal accessibility program looks like, and the cycle that you would want to build into your development team.
Yeah, great. So as Michael said, to make a product accessible, there are specific steps that need to be taken. And it all starts with assessment. Assessment is the key elements that allowed us to understand what is our status, where we want to, what are the goals, in which time frame we need to achieve these goals, and what are the steps that need to be taken, and who are the teams members that need to participate. And usually these steps, it's the based on our experience with enterprise and other organization, it's early in the process. It's allowed them to prepare all that what they need before they dig in and try to now solve the accessibility level of their products. And we are happy to say that as a vendor in digital accessibility and the provider of platform to ensure that they have the tools and the knowledge, we recently add the component that help to, in an interactive way, and of course with a lot of AI and other questions and answers that the customers provide, to build the accessibility maturity model. That's how it's called. It's the accessibility program. And it's questionnaire, very simple, around 35 questions. But each answer will make the organization first to think, second to assess what they have, what they don't have, what they need to complete from knowledge perspective, and of course tools. But this will allow them to get on the fly an interactive map, what their status, what are the next steps, how they need to achieve that. And of course, it's also connected to our tools that will allow them to understand in each milestone which tool is the relevant one, which component could helping them to achieve the goals much faster and much more automatically. Steven.
Great. So, can you take us through sort of some of the different issues that the industry is sort of currently, some of the hardships that come up when trying to design a accessibility program in today's environment?
Absolutely. I think that the main challenge for most of the organization is knowledge. And they have law from one hand, they have technology in the other, and between that, they have people that need to understand what they need to do. The knowledge is the key element that need to be enclosed. The gap should be closed. So this is, I see in many of the organizations that we are served, the number one element. Second, of course, that if Michael said they're doing that afterwards and not as design with accessibility in mind or shift left approach, it's become very expensive, and budget become the second challenge for most of the organization. I must admit that we serve some of the largest brand in the world, and we still see that the accessibility department or the accessibility budget are very, very limited. Comparing the fact that this is a law and it's a mandate, and it could harm the organization, not to mention that it's also could lead to less revenues. This is something that need to be improved, but in many organizations, it's still not the case. And this is something that add additional layer of challenge. Addition to that, most of the job today and most of the service provider in the industry still provide a lot of service manually. It's lead to slowness. I must to say also that the fact that organization locally and of course internationally, they rely on global labor and communication or lack of communication, not using the same vocabulary between the team members, different time zones, etc. And the way that they're working today, that it's mostly manually with Excel files and emails, and that's kind of communication, lead to slowness that impact their success to achieve the goal in a reasonable time. And of course, incomplete. If you do not get all the information, where are your defects exist, what the impact, and again, it's connected also to the knowledge, it's lead to incomplete solutions that could lead to legal exposure that need to be covered. And those, I believe that the main four issues or challenges that slowness the digital accessibility program in organization and achieve the goals.
Right. So what then should we be looking for? We have some key accessibility program principles that I know me and you have discussed at length, but so if you could walk us through those to try to mitigate some of those issues simply.
Yeah, so as in Allyable, the focus in make it first the thing simple. We understand the gap of knowledge and the experience, and of course that complicated law rules need to be simplified as most as possible. So our first approach is to make it simple to use, simple to understand, and simple to track, and understand how the progress is going on. Secondly, of course, advanced technology. I truly believe that technology could close the gap. I think that we're facing that with AI in the last 2 years. A lot of things that was impossible 2 years ago, everybody say today that it's impossible. It's possible. We're seeing that in visual computing. We're seeing that with writing code much faster, closing gap in knowledge in no time, and of course agentic that do the job instead of us. But in the same time, digital accessibility, it's about the end user experience. It's no matter if your AI will write you a perfect code, but in the other hand, the user that will try to use your product deal with specific things that the AI didn't aware to. And in that case, you will be failure and you will be illegal exposure. So advanced technology have advantages, but need to know how to use them in the right way. And the last, and I think the most important thing, is it's accurate of information. As I mentioned, a lot of end users using digital assets in different ways. They come from different computers, different devices, mobile devices, different browsers. They use different permission that change the interface for them. Based on that, they arrive to the asset from different locations. Sometimes they deal with dynamic content that change consistently based on their location or the permission or other element. And all of that add the fact that some of them dealing with disability that change their experience. We need tools that will understand that and capture each unique scenario. So in that case, the people that design or develop the product could give a solution for that. So the corrective information, and that's the most important thing in order not to fall in the between the cracks.
Right. So people because if the accurate information part is specifically for um, the project managers and the program leaders and the people who are the accessibility officers in a company or an organization. It's so important that they understand sort of on a day-to-day where they are with their program so that they can continue to make progress on it. Because without
It's
that,
that
you're lost.
it's it's that of absolutely, but it's also about the different law, because the European regulation and the American regulation and the Canadian and different states have specific things that sometimes impact also differently. You need to understand that you capture all. If you capture all, you could take steps to remediate that. If you do not capture all, so you miss things. And if you miss things, in the end, equal access limited.
Right. So what is mapping a program like that first key step? Like what does that look like, David?
So as I mentioned, we built an interactive tool. The interactive tool allow to Allyable customers to being asked about different aspects of their goals and the program that they look into. Who are the team members? Who involved? What is the level of knowledge? Uh, the location? Of, does the work is done internally or externally? And which guidelines they want to hit, and what are the assets that they want to make accessible. And based on all this information and based on a lot of data that we have, we analyze in a real time the right program that will fit for the specific organization to the specific program. And as I mentioned, it's allow you to get a map about what actually your strength, what is the things, the weakness that you need to accomplish or close in order to achieve faster resolution. And then it's lead you to the plan, the program itself, everything in very easy access and user-friendly way that even non-experts could actually benefit from it. And then attach to each milestone in the program to the relevant tools in the Allyable platform. And we have several tools that need to cover all aspects of digital accessibility, starting from auditing and assessment through validate coding in order to design with accessibility in mind, through tools of MCP and AI in order to ensure that developers saving time and getting what they need, integrations to CI/CD, and several more elements, including, of course, document accessibility and media accessibility for captioning and PDF accessibility. So everything including the platform. And for those that doesn't have the knowledge, they of course have a academy. It's online training tools that helping them to get all the information, all the knowledge in one place, uh, with agentic GPT that you could ask specific questions about anything about digital accessibility or inaccessibility, and you will get answers in no time. That's helped to organization, mostly global organization, and also with a lot of employees to spread the knowledge and get answers even when the accessibility teams it's small or with a limited budget and could not answer all of the people in the organization, as well as different time zones. Once the accessibility teams, they sleeping in the United States, but maybe in Europe they wake and they need to get an answer right now. So they get the answers in real time, including which tools that they need to use and how to use them.
So
I think this is the revolution of AI and automation.
So David, real quick, we have a question jump into the chat here. Speaking of PDFs, which is I think is a really good place to put this, and I'll open this to both of you just because this popped up quickly. Are there any issues with DRM conflicting with accessibility requirements for PDF documents, referring to decades-old repositories or scientific research on the internet?
Michael, do you want to answer that?
Sure, I can take a first stab at it. I don't have any specific scientific data on this. However, from my personal experience as a blind screen reader user, I have observed security features sometimes interfering with the navigability of certain PDF documents. Some documents I know are very locked down, secured in various ways, and on very rare occasions, JAWS would not be able to read the content at all. Sometimes I would be able to overcome that barrier by running optical character recognition on the document, which essentially extracts any text that's in the document from the document itself. But I have encountered cases in which even OCR would not work on a very tightly secured document. I don't know if David, you have any more technical or scientific data on this?
Sure. From PDF perspective, every page of the PDF should be accessible, and there are specific guidelines how to, when you prepare the PDF in advance, in, as we say, shift left, but shift left in documentation, you need to design and write the documents in accessible way. If you're using different tools like Office, you have embedded tools to helping you to ensure that the document is accessible. But once you convert it to a PDF, you must ensure that it's tagged in a proper way for screen readers and others. And definitely the recommendation is that if you have images, you need to provide alternative text for each image and description. If they have different colors, color contrast, etc. And as well, need to be aware that not all documents need to be accessible. But I think that Michael could elaborate a little bit more from which year it's the obligation. So repositories and other, if they in use today and they need to serve today, it's really important to make them accessible so they will be valid for anyone, for everyone. But in the same time, the law doesn't require, I think back in 2017 and back, should not be accessible, but any new documents that we produce must be accessible. The good news is the Allyable do helping you to make your asset, your documents PDF accessible in a very easy way. You upload the documents into our platform and you will get it in an accessible way in no time. So I hope that we answer the question.
I think so. I think that gave a pretty good overview, at least to the best of my understanding. So, David, just real quick, if you would like to just sort of take us through kind of like what a platform should look like Allyable's, as far as like, you know, providing an overarching ability to implement an accessibility program. And I will note that we are coming up here on our time. So if we can be brief.
Sure, absolutely. So our main mission is to be the one-stop shop for anything that's requiring digital accessibility. Our goal is to help to any organization, no matter the size, no matter if it's a local, domestic only, or internationally, to gain control on the digital accessibility journey. Digital accessibility it's a real journey. It's a no one time. It should be invested all the time, consistently. And so we add to our platform, combining our platform, different models that will help to any organization to get all the knowledge and all the tools that they require, starting from academy through code assistance and development tools for the developers, testers, product managers, Of course, doing assessment 24/7 in real time, all the time, to identify violations before the organization get impact, and get all the insight, get the steps how to remediate, building the program, of course, allow to keep security in place because organization need to keep secure even they doing digital accessibility, how to manage digital accessibility project and all the manual aspect that related to digital accessibility, mostly in the auditing side, and much more faster and efficient, and of course to collaborate between different stakeholders in the organization. And last, as we mentioned, to enable document accessibility, media accessibility, and of course, help to our customers and organizations that working with us with experts, and that for any element that required additional knowledge, additional point of view, and legal help, to help to our organization to achieve that. So everything in one platform, very easy to start and implement, and we will be more than happy to answer any questions in that case.
Great. We have another question, David, that I know is an interesting one. Is David, will you be attending Disability In Conference next week? And I know the answer to that one already. Is that
yes, we will participate in disability, and we will be more than happy to meet each one of you in person if you are attend.
But you will be meeting me, and David probably will not be attending. You will be meeting me instead. Great. And then real quick, if you guys could both just give me sort of a breakdown of the importance of and generating and the ability to generate accessibility conformance reports on demand and why this is so important, particularly if you were working with any sort of public entity. I would love to hear your thoughts really quick on that.
Yeah, so in the end, they have some material or some final reports that will help to any organization to get the status of their product. This is what most of the government institution, health institution, if you are a provider of a product, will require from you. And the report is based on standards that are set by the W3C and also by the disability and accessibility organizations. And the Allyable platform, if you work with the tools and with the knowledge in the right way, will produce for you on demand, on the fly, the ACR based on your specific situation and status in the right moment. And it also will help during the program when it's moving on that the VPAT and the ACR reports will improve. This is help for many organizations to check themselves, and also if they selling their product or offering their product to their potential customers, to provide the necessary documents that today I see that more and more required by RFPs and tenders across the globe.
Excellent. And then just sort of to bring it back, is that once one has created basically that accessibility program, the importance of basically beginning the cycle over again. David, can you just take us really quickly through that? Because this is an ongoing challenge. It's not something that goes away. You set it one time, you get good with, compliance or best practices, and then you just let it go, right?
Yeah, as we all know, digital change consistently. It's required from us to maintain what we are doing. And of course, every new things to ensure that they are accessible from the get-go. This is a cycle that will repeat itself again and again. And it's not a one-time job. And that's perspective. I'm happy to say that today it's more, they got more awareness for that. A few years ago, people say, hey, we just make it accessible and that's it, we're done. It's not done. You need to continue investing in it. And that's how it should be.
Excellent. And we did build in a little bit of Q&A, but we already actually took some of those questions. I know a question in here actually to round us out. That is, will this be recorded this presentation and emailed out? Yes, it will be. Everyone who has attended, everyone who is registered, and please share this as widely as you would like to. This will be sent to everyone who has attended and registered sometime in the next 48 hours. And please share it out to anyone who you think this will be a useful amount of information. I would like to really thank Michael Nowicki for giving us a great overview of the ADA on its 36th anniversary, taking us through all the different titles, what it means to us today, and how these laws apply in addition to the other subsequent laws, and also David for his insight on everything accessibility program. Thank you very much, guys. I really appreciate
Thank you
this.
very much for the opportunity.
It has been a great webinar. Thank you.
Bye bye.
Thank you, everyone. We will talk to you soon. You will hear from us.